Lord,
They have
why
not
should you
even
make
issued
that
a
statement?
lookout circular.
I am in India, I am before
They
the
have
court.
not even
I am
issued
not
a
running
lookout
away.
circular
I am not going anywhere.
which will prevent him from fleeing the country. So many people, my lord, with tens of thousands of crores outstanding have fled the country.
There is an
At
LOC
least- at
against
least
him, my lord.
There are several LOCs. I have not gone. I have not attempted to go. I am, my lord, working in my office in these companies even today.
That I think that having been issued, they can't now.
And I am not going, my lord. There is no question.
Lookout order.
Lookout
Issue a
circulars are
lookout
issued.
circular.
There are several of them, not one. my lord.
They can't allow him to flee the country. At
Arre
least a
bhai.
lookout circular, even if they are.
Why is
not-
my friend making this statement, my lord? Is there any material to say that I have fled the country or have fled the country?
You have-
We have repaid 20,000 crores in the last 3 years. If I had to go, I would have fled earlier. Not now.
a per-
Why do you make these kind of statements?
Now because
Just because of the press.
Because the court is monitoring the matter now. That's why I'm saying.
So where is the?
That's why.
Show me one stretch, one shred of evidence to suggest, my lord, that this man is running away.
Solicitor General, you, whatever necessary steps are required, because we do not want anything to happen which may frustrate the ongoing investigation.
I understand.
You
Lord.
must
A
take-
line from your lordship, my lord, would really.
We must take whatever preventive or other measures are required to be taken. We do not want that investigations are hampered at any cost.
Observation करने के लिए सब सिद्ध program.
My lord, statement, I will not leave the country without the leave of the court. What more is required?
Lord,
Just to make, my lord, allegations against us?
My lord, only a minute, only a minute. My lord,
At this
my lord, there is something I want to say at this stage.
Mr. Prashant Bhushan, learned counsel for the petition.
R5, my lord.
My lord, before your lordship dictates, my lord, one thing.
Huh.
My lord, I respect Mr. Rodgi's statement, but in past, my lord, he has also burnt his fingers. He made a similar statement in favor of one of the clients, my lord, before Delhi High Court, and the person did flee. I'm not saying, my lord, about this person.
But he came back and he paid 5,000 crores to this government. Let's be
But
very clear.
after 5-6
Once
years, but
he-
sometimes,
once he-
my lord, statement becomes, my lord, embarrassing for the
Once
counsel.
he is out of the country, what good is a statement? Once he leaves
My
the
lord, then
country,
there is no reason to trust anybody. Then there should be no, why statement should be recorded about anything?
in a
What
matter
is this
of
kind of
this
argument?
kind,
We will
My lord,
say at
one
this-
will flee
at
after
this
the
stage-
statement for if
At this
100
stage,
people.
Mr. Prashant Bhushan, learned counsel for the petitioner, states that,
Very, very unfair.
that
Make these allegations.
owing to the
he is responding.
alleged, owing to the amount of alleged fraud involved and the action now and the matter having, being investigated under the supervision of this court, there is every likelihood of the principal accused fleeing from country. On this, Mr. Mukul Rothgil and senior counsel representing respondent number 5
Yes, ma'am.
states that that his client will not leave the country without prior permission
Of this court.
without prior permission of this court. Full stop. Mr. Solicitor General of India, and assures that all remedial actions,
Preventive actions.
preventive
Preventive.
and remedial actions will be taken to ensure that no impediment is caused in the ongoing investigation.
Yes, certainly.
That's fine.
Because the
I'm
other,
grateful, my lord.
because we haven't had the advantage, of course, of these sealed envelopes. We really don't know
They
what
are
is in it.
pending
We
investigations.
know this we know this a bit about the affidavit which the Enforcement Directorate has filed. So, because your lordship may give us 3 weeks because at this stage,
4 weeks we are done
yes, for a counter affidavit.
for counter.
Yes. Please do that because this is on denials. We are denying these allegations fully, Milal, because otherwise the court ultimately is
We
going
are
to
not
the
taking-
appellate remedy.
That's why we are very careful in
Yes, your
using
lordship,
the word.
We have seen them.
And
That-
we are also granting you time. 4 weeks.
Absolutely, absolutely. Absolutely.
I'm grateful, my lord.
Would like to.
Lord, kindly come to page number 63, my lord. Lord, 2 years after construction of the overhead tank, kindly come to page 63, my lord.
Commercial loans also provided with the bank. And I have paid everything. I have got no due certificate.
63, my lord. Lord, we have constructed a overhead tank, my lord, for the purpose of this Ilayangudi village, and my
This
lord, we are
the water tank.
a water tank, and my lord, a small panchayat office is there. My lord, on a land, my lord, disused land, my lord, which was originally, my lord, a village pond and later classified as, my lord, a disused land. My lord, in fact, we have an hydrological report also saying this construction will not anyway affect in the other part of the land, my lord, which is retained still as a pond. My lord, the High Court, my lord, directs us, my lord, to remove, calling it as an encroachment.
It's not.
And thousands of, my lord, yes, my lord.
And water completely.
And 3,000 direct beneficiaries of this water. My lord, fresh matter, my lord, coming for,
Issue.
some delay also is there.
Delay condom, issue notice returnable on so and so date. Meanwhile, operation of the interim judgment of the High Court shall remain still.
Lord, R1 is the writ petitioner, others and all were respondents, my lord, along with the
Say,
former councillors and all.
so notice returnable on so and so date. जो है, delay भी इनको सुनकर के कर दे तो ज्यादा delay. Review is 107 days.
जब ज्यादा नहीं है उसके बाद
And bill 380. So 900. I returnable on so and so date.
Stay, my lord.
Number one being the contesting respondent, comma, the service on pro forma respondents is dispensed with. Respondent number one may be served through the notice also. Meanwhile, operation of the interim judgment and order of the High Court shall remain stay. Consequently, the water tank, there shall be no demolition of the Panchayat Bhavan or the water tank.
Grateful to you, lord.
Hey, please, your lordship. This is another interesting kind of bank fraud. It's, every day, my lord, they come out with
Serious
unique,
objection for saying this one.
unique ways.
Absolutely.
हुआ था दो graduations.
Your lordship should see how a genuine transaction is put into so much of court pressure. We should give us 2 minutes, my lord.
I appear for.
Genuine genuine commercial bank transaction put into so much of pressure and anguish, my lord. Please see the number. We have recovered 116% of the loan amount. And now he wants an inquiry. Absolutely a roving inquiry without any basis. Please see the numbers.
They are so worried that they don't.
No way.
want
No,
me to
this kind
speak.
of slings in the dark. What the High Court says.
Mr.
at page
Bhushan,
30.
you have also
Highly
to understand that this is a commercial transaction where the ledger value has already been
Recovered and more.
to the
One second.
auction. Then
No, no, Lord, ledger value has not been recovered.
that's
In
the
fact,
finding, sir.
no, the
Please.
company itself says that they have made a profit of so and so because
Oh,
of this one-time settlement. If your lordship now turns to page,
Kindly turn to page 30 of the.
actually,
High
my lord,
Court.
at page,
Page 30.
we have analyzed at page 189, what was due and what has been recovered. By this, if your lo-
Come to page 9, 7.2. It
Yes,
is
7.2.
116% of the ledger.
Please,
value.
I got the calculations. Lordship may see the
that is,
calculations.
on- that,
This is not able.
that is only the principal amount, not with interest. What was due with interest is, my lord, given at page 189. Otherwise, there would be no need for a one-time settlement. The only reason why they entered into a one-time settlement was because they said, and the bank said that, look, now the property has been devalued from 2,600 crores to 970 crores. Something very astounding. In 2021, my lord, this hotel was valued by the same valuer for the bank at 2,600 crores. 3 years later, in 2024, the same valuer values this same hotel at 970 crores, 1/3 of what he valued 3 years ago.
What was the mode of auctioning?
Mode of, no auction. What they said was,
Two options.
It's a settlement.
what they said was, we will enter into a one-time settlement. And the one-time settlement,
Commercial law, comparable, that was wrong. If you have a hotel use, the value is lesser than a commercial use, that's why it was done. And after I had paid everything and obtained a no use, this petition is
My
filed.
lord,
How much was the total loan
yes,
liability?
my lords may see, my lord, the court has gone into, lordship may see the sheet of paper, only one
just
sheet,
show-
my lord, which we have given to your lordship.
if your
And see
lord-
the second sheet. Only two sheets were,
Tell us, how much was the,
my lords may see the numbers. Yes, your lordship may see the numbers. Loan sanctioned is
loan with
242.61 crores.
240?
I have given the sheet, my lord. I have given a sheet of paper with these numbers. Yeah,
Very
please.
good.
Yeah, please.
that was the original
Yes,
loan.
one minute, please, Mr. My lord, loan sanctioned is 242.61 crores. Ledger balance at the time of OTS is 226.54 crores. Total amounts recovered is 414.6 crores. Profit of 172.
No,
It-
Mr. Venkataman. This 242 crore was given in which year?
I'll give the year in a minute. I'll give it in a year in a minute.
March
2015.
20.
2015.
15.
Yes.
Now, out of this principal amount of 242,
Yeah, they have paid so far, 400, including all the settlement, 414.63, line 3.
that 414 is paid only in OTS.
No. If your lordship sees the second line, 242 came down to 226 at the time of OTS because interest, always bank takes interest first. So once OTS has been compounded, the total amount recovered by the bank is 414.61 crores. And my lord, the date of declaration of the NPA is 31/12/2020. Bank sanctioned a one-time settlement of 265 crores.
No. This 414 crore is paid when?
No, my lord, since inception, my final payment was made in 20.
Actually, my lord, at a glance, your lordship can see.
OTS amount in 2023.
In the COVID period, the hotel was empty, we were declared in NPA.
NPA.
The hotel is empty, it can't pay anything. That's across the
For
country.
3 years.
When they created a default, we challenged it. He said, we are not a default, and if the hotel is not establishment can't.
No, Mr. Rothgi, if the account is declared NPA
Yeah.
and the assets of the borrower are valuing more than what the total due amount, in that case, normally, what these bank people do, they always go for auction. They don't allow a poor resident.
No, we exercised the option twice.
100 square yard house, they will throw him out, will put him in auction because
We went for auction twice and it failed. We have exercised that option. It's not that bank has not done it and it failed.
We questioned it, in COVID, the hotel was empty, he was suffering a loss of 100 crores, Lord.
किसी गरीब आदमी को ना।
And my lord, please see
Prior to COVID,
on the valuation.
1 minute.
prior to COVID, we were fine.
there.
COVID, Lord, created a problem for all kinds of, Lord, luxury establishments like hotels. We were questioning, Lord, our NPA. Finally, Lord, this was the figure which was being.
No, but this unfortunately settlement is in 2025.
Now, yes.
2024.
So before, in 2025, on 24th January 2025,
Yes.
before that, when did you put the hotel for auction?
Yes, for 2 days. We have done it twice and it failed. We'll give the dates. Twice we have done the auction, we'll give the date. Asset reconstruction auction will not took place in 2 dates. Lord,
2023.
P6 and P5, my lord. P5 and P6. One is, my lord, dated.
कहाँ है प्रिंट?
2023. Yes.
ऑफिस बेंच के लिए है बीच में फोन आपको पैरास मार्क्ड है पैरास मार्क्ड साहब
5/9/2023 and my lord, 29/11/2020.
No, 5/9/2023, what was the highest bid?
No bid was received in both.
After, then, In 5/1993, first of all, please show us the records of the auction. Please produce the record of the auction.
We'll do that. Will you not kindly
After
tell?
1993, 2023, then you are entering into an OTS on 24th January 2025.
Yes.
Even a layman in Delhi can take notice of this fact that what is the value of a five-star hotel in Delhi.
Just
Lord,
see.
There was a moratorium stay for
Just see-
3 years
just see
because of COVID.
page
So, my lord,
So that 3 years is
High
over.
Court, because of a High Court order.
If your lordship
That
just
3
sees.
years is over when in 2023 you try to auction it. That
Yes.
means that 3-year moratorium period was over.
Yes, yes.
Now from 23 to 25, when anybody on the earth can take judicial notice of this fact that the value of real estate properties are rising, and you have a 5 or 7-star hotel here, you enter into an OTS. Before that, you don't make any attempt to auction it.
But we have done it. My lord, with great, my lord, 2 facts have not, but the High Court has recorded 2 facts. My lord,
Now,
2,
please produce the records of the auction. We would like to see it.
Yes.
Your Lordship, just 1 second.
In fact, my lord, if your lordship turns to page 252, just turn to page 252.
my lord, nobody
is-
can then come, enter into a
just
commercial understanding of an
check in
OTS.
252.
When, my lord, in IBC process, 90%, this is a case of a recovery of 116%. Your lordship is now, my lord, to say that this should be,
As a matter of principle, in the commercial wisdom of the banks or the financial institutions, we will not interfere. There is no question of it. But when we are talking of your commercial wisdom,
yes,
we also know it very well that you are not a private entity.
no doubt,
The funds which you have are the public funds.
no doubt, my lord.
These are this money belong to the people of this country.
Yes.
Therefore, your commercial wisdom is for the purpose of giving undue benefit to a person, or it is to protect the public interest.
Which is not
That
their
part will
case.
have to be
With
investigated.
greatest respect, my lord, today, the case of the petitioner is a roving inquiry. He doesn't make out any case.
We are not concerned about the petitioner.
Yes, answerable to the
He
court.
might have been- we will go to the extent that the petitioner has been planted by some rival. Somebody who wanted to buy the hotel couldn't buy. Let us take it like that, worst part. But now that a fact has been brought to the notice of the court,
Yes.
we should satisfy our conscience that the things have taken place in a transparent
Yes.
and fair manner.
Lord, which is what the court has said.
If your
We'll take the
lordship
findings of the court, my lord, but finding after finding.
just sees one page.
Hotel was not, my lord, having any default prior to COVID. It suffered a default. The government of India, my lord, also issued circulars in regard to this period of default. If I have come out of it, they did try to sell. After that, I am back on my feet and I have paid. Is it a case?
Mr. Rotigi, we have no difficulty. Every day, day in, day out, in matters before us,
Yeah.
the plea taken by these very banks is, we will not enter into any OTS because the value mortgage by them is much more than my loan amount. Therefore, why should I go into OTS? This is the consistent stand they take before us.
Look at-
That we are not going to accept any OTS
Look-
because we have an asset, we will auction it and we will recover entire amount.
But, my lord, is it appropriate that a man who suffers, my lord, great losses during COVID, not a single room in the hotel, my lord, was functioning?
No, we are talking of, had the settlement been in 2020,
Yeah.
things would have been different. The settlement is taking place in 2025. This OTS is in 2025,
Yeah.
when the entire, hospitality sector, the hotel, they are flourishing.
Yeah.
They have wonderful business, each one of them making money. A 5-star hotel in Delhi has its own value. People know it very well. Who is going in the street, who is going to believe it, that this hotel has a value of 300, 400 crores? When the value might be 4,000, 5,000 crore.
It's not- they do- well, 4 valuation reports are
Debt
offered.
was only 200.
4.
The debt was 200,
Fine.
250. It is settled at 400.
Why
Therefore,
settlement?
2 things, let them produce. First, produce your ledger books that if going by the rate of interest and all, as per the original loan agreement, what was the total amount as on 24th January 2025?
We shall, my lord, a special committee comprising of a retired judge and 4 other bank has come, Lord, this OTS was decided ultimately not by the bank alone. It had 5 people in the committee headed by a retired judge, which decided what should be the OTS amount.
Then immediately produce this report. We would like to see the report of that learned retired judge also.
No,
Please
it's,
produce that report.
I just want to make one small request, Your Lordship. I'm appearing for the bank. The committee consisted of 5 persons, a RBI nominee, a Government of India nominee,
Retired judge.
If your lordship just sees,
Besides the bank official, there's a RBI nominee, a Government of India nominee, and a shareholder nominee. They were all independent persons who had nothing to do with the banks playing any fraud in this case.
No.
And they kindly, therefore,
We have no doubt about their independence, Mr. Attorney. This all depends upon what the facts are.
no,
produced
your
before them.
lordship's question is certainly well placed, but the question is,
It is something like whatever in a writ petition or in a counter affidavit is brought before us. Based upon that set of facts, we take a view. Our view, despite the fact that nobody will question our bona fide, nobody will question our independence, but still our view can be erroneous.
certainly, we go by that.
It's not brought on
We
record.
certainly go by that proposition, but the High Court said, I've looked into all these aspects.
Yes.
High Court goes into an independent of the settlement committee. High Court says at 12:30, I
These are
don't
detailed-
find these are roving inquiry
Yes.
for no good reason.
Absolutely a non-serious,
inquiry.
my lord, non-serious, vague, bald, sweeping allegation on, my lord, a bank, on a my lord, we are not defending every transaction. We ourselves come. But, my lord, to say that therefore every transaction has to be, my lord, 5 million transactions happen every day. If you are going to put, my lord, a spokes to, my lord, through a process to say that this should, my lord,
Mr. Venkataraman, unfortunately, we are not saying that every transaction, but many of the transactions.
Certainly,
that
my lord,
take place,
we
and
are-
particularly
Provided.
under this, the direct or indirect umbrella of this IBC.
yes, yes. my lord,
These have become a very, very doubtful, very doubtful manner. A poor lady, a widow woman came to this court. She was before us with tears in her eyes. She wanted to pay 30 lakhs to a bank. They refused because they wanted to 46 lakh. She lost her husband. That's why the default was committed. We had to come to her rescue only to protect her residential house. When question of their case, they said, no. The value of the house is more than 50 lakhs. We have to recover only 46 lakh. Why we should enter into OTS?
Those,
This
those-
is the stand, these commercial wisdom people take before us.
There are-
And when the question of a 7-star hotel come, the stand is altogether different. Why our conscience will not prick? Why should we accept it?
may I only persuade on one aspect?
Please produce the records. I would like to satisfy myself.
your lordship will do that. I only want.
My, so will be my brother. Let the original records of
The settlement.
the bank, complete details of the loan amount which was due as on 24th January 2025, the report of an independent valuer, if any, assessing the
Four value will be produced.
market value of the hotel as on 31st December 2024, that is immediate before OTS, and other relevant reports be produced.
Well, there are four valuation reports converging on value, except for the one odd value report, which said, well, this is a hotel. We can't sell a hotel. Well, valuation demands, hotel cannot be sold as some industry. One odd valuer gives a report of 2,000 crores, which my friend is relying upon, who says it's a commercial property. It's and one whole building is left out from the loan. Loan is not, ultimately the mortgage is only limited to a few sections of the whole. He values the whole. He values the whole as commercial, contrary to four bank authentic valuers who all confirm what this value of this hotel would be at a given point of time. Four concurrent valuation reports. Well, the High Court spent a lot of time. Well, we'll certainly persuade your lordship. No difficulty.
Venkataraman,
But only thing, my lord,
we have recently, incidentally before my bench only, we have dealt with the auctioning of 2 hotels in Kerala. We have seen the people come forward to buy hotels also. There is absolutely, it's not that people, there the prospective buyers are not available.
we have no difficulty in producing.
Understandable. Suppose you say that I have tried my best in December 2024. I could not auction it. I did not get a single bid. And therefore I had no choice but to go for OTS. We will accept it.
That's precisely
That
what
is
happened.
commercial wisdom.
Precisely what has
What has
happened.
happened?
Not even otherwise.
We will produce the records.
Things have lot of.
We'll produce the.
just see one page, my lord,
Which I
page
suffered in
page
COVID. Why should
252.
the hotel be sold?
Two-
Apart from that,
We are not saying.
it's not that I was not a default.
If a borrower,
Siphoning
Mr. Rotgi, if a borrower, small or big,
Yeah.
if he can save his mortgage property by paying to the bank a reasonable amount, no difficulty.
Correct.
But not in this manner. If at all, it seems to be. Therefore,
I think, Lord, your lordship will be satisfied on the manner. Lord, I'm sorry, but your lordship will be satisfied. I think, Lord, this,
Yes, yes,
Lord, this is an
I would
litigant
never
who is
stand for
just
it, my lord. Your
going
lordship
hammer
can
and
trust us.
tongs will
We'll show anything.
satisfy your
There's no
lordship.
difficulty. We'll show it, my lord.
Just
Absolutely
first
no
see
problem.
one page.
Lord, the
page
other issue will be,
252
can you really upset
of the
TSs
paper
which are done in this manner?
Page
when complete contrast cases come before us, we get disturbed only because we do not know what's happening.
Absolutely. There we are with your lordships.
But your lordship will be satisfied.
We'll have to pick the oranges from the apples, certainly.
The OTSs are happening in this country. If not
Yes,
every
yes.
matter is.
Lord, a very, Lord, a very,
There is any
we say this with a sense of responsibility. An extremely genuine OTS transaction is what has been brought unnecessarily into scanner. That statement we will make to
Say
the
notice to responder 4 and 5, 4 to 6 only at this stage. Number 1, notice to responder 1, 4 to 6, and 4 to 6 at this stage. Then also report is produced. It's after.
Therefore,
I am obliged.
oblige your lordships.
Ah, chal.
But office report shows on 4 earlier occasions SLP is dismissed.
May I just place my matter? I'll place all of that. I'll place that. I'm for the petitioner. This is a writ. The only question, I'm pressing in this writ is my prayer A. What is happening? I'm not seeking any relief in respect of the matter, which is prayer B. The only relief is prayer A. Your lordships will have at page 17. what is happening in the state of Telangana, my lords, is
Mr.
that
Prasad, how
Yes.
many time your petition will be entertained? First
plus
of
no
all,
repetition. Plus what has happened is page 237, your lordships, I had come up in a SLP all the way, and at page 237 is that order where the liberty was given. My lords, just hear me for 1 minute. I see that, my lords. I have come in a SLP. Let me explain that. And the liberty was given at page 237. Your lordships will have that order.
file SLP. Please see the order.
Yes. My lords, page 237 is the SLP. And my lords,
Remedy. And you file another SLP challenging
no,
this.
no, my lords, I have filed only one SLP that was knocked out on the point of delay. The question was never considered. That came before Justice Narasimha's bench. The bench observed that earlier order. Yes.
Mr. Prasad, then
Yes,
that means if we dismiss the SLP, we decline to entertain SLP.
Yes.
According to you, the second SLP is maintainable.
No, this is a writ petition. This is a writ. My lords, the court indicated that please, we are not going to, because against the same, my lords, against the same order, the question, only the legal question, because in the state of Telangana, well, the court indicated that if you have to move, please move a writ. That's why that gave me a liberty. I am not seeking any relief in respect of this matter, but what's happening in Telangana, your lordships will just consider one thing, my lords. What's happening is reserve candidates are being counted if they are meritorious against general seats. So, my lords, which is incorrect, because the law is very well settled. If I on my own merit make it in the general, then it has to be treated as I am.
SLP,
Because the SLP was dismissed on the ground of delay. So the High Court also didn't engage with this issue. The court at page 237, that's the order I had myself appeared, indicated we can't engage in this because I have dismissed an earlier order, earlier SLP against the same matter by some other party. Therefore, if you have to file a writ. That is why the liberty was given at page 237. And pursuant to that, I am filing. I am not seeking any relief or stoppage of the process here. I am only saying my laws will settle the law so that for future there is no problem in Telangana. That's the only prayer. This your lordships may not interfere. My laws may record my submission straight away. I am not seeking interference with this process now. Because otherwise every year this will be happening, my lords.
thank you very much. We will not entertain this.
All right, my lords.
The
Great.
petitioner has already lost the first round of litigation up to this court with dismissal of SLP civil number 16170/2025. So, we are just of the view that the second round through this litigation is wholly misconceived, misdirected and not maintainable. Dismissed.
Great. Because I'm for the petitioner, my lord. These are two matters, my lord. My lord, similar matters have been, my lord, decided, my lord.
But these are fresh matters.
My lord, these are fresh matters. my lord.
Fresh. Any matter already pending where we can tag
My lords, as per the office report, no, my lords.
issue notice, trustee, liberty to serve the state through standing conflict.
Most grateful, your lords.
In the earlier notice recalled on Sunday. Item 6. Already dismissed.
Please, your lordship. Lordship, this particular matter, as per the office report, this is already.
Similar matters have already been dismissed.
Yes, your lordship.
Same order. Item 7.
Wait, please, Lord. Because I've just set out these, and just see the pleadings. Look, just see the pleadings against defend number 17. I've just put them. Just hand that up. My lords may just see this. Look, I've just summarized, I've set out the pleadings against 17. Just see that for a moment.
Apply order 1, rule 10, discretionary relief. Why?
Order 1, rule 10 2, but just see the pleadings here. Just see that for a moment. This is not, it's a case which.
That a case cannot be maintained against a shareholder when the cause of action is against the company. That is your argument.
No, but there's nothing against the shareholder. Just see the pleading. Ultimately, even against the shareholder, there should be some pleading. Just see that pleading for a moment. Give me, just indulge me. I'm not asking your lordship to open the papers. I've set it out here. Just let me read that, lords. I've set out in extenso
I've reproduced it exactly. Just similar. The solitary pleadings in the plaint with regard to D17, plaint is from 38 to 107. It's a 90-page plaint. Para 18, the 15 to 19th and 21 to 28 defendants are shareholders of first defendant and are therefore beneficiaries of the trades done by first defendant on the plaintiff's exchange. Para 91, the plaintiffs state that in view of the fraud and default committed by the defendants are jointly and severally liable to pay the outstanding amount with interest in respect of the said outstanding trades to the plaintiff. Para 111, the plaintiff therefore submits that this is an imminently fit case to secure the claim of plaintiff by attachment of all the assets of so-and-so, so-and-so, so-and-so defendants, since the liability of first defendant admitted by them runs into hundreds of crores of rupees, and the defendants are consistent with an intention to defeat and defraud the claim, which is manifestly evident by the act of restricting inspection of exchange designated warehouses. Prayer is this honorable court be pleased to pass a decree and order directing first, third to 41st and 45th to 50th defendant to jointly and severally pay 937 crores. Now, they relied before the High Court on this para 87. Just see overleaf. Para 87, the High Court just merely sets out the para. Just see para 87. It is pertinent to mention that from September 2009, when the first defendant commenced trading on plaintiff exchange, till August 2013, the management and the affairs of first defendant was run by the 6th and 7th defendant. In fact, 6th and 7th defendants were actively involved in the transactions entered into by first defendant on plaintiff exchange. The entire conspiracy to defraud the plaintiff exchange was conceived of and orchestrated by 6th and 7th defendants. It appears that the companies owned by 6th and or 7th defendants and other companies firm, which in turn were owned by individuals who are related or connected to 6th and 7th defendants, benefited from or participated in the fraud. The directors, shareholders of first to fourth defendants are either family members of 6th and 7th defendants and or people accustomed to acting on instruction. I'm not a director. My father
was a director.
he resigned in 2013. Suit is filed in 2021. 8 years after he resigned as a director.
And see,
No averment against my father.
the Roman 9, clause 9, Roman 9 of paragraph 87, that the shareholders are in collusion with the directors in respect of the fraud.
I'm not a shareholder.
You are a shareholder.
No,
You
I'm sorry.
Paragraph 18.
It's a public limited company. I'm
a shareholder of the company. Your plea for dismissal is no dividends have been declared, so there is no.
I'm sorry, my lords. Please just see the law laid down by your lordships. This is this opens
The law
up.
laid down by us is not to substitute a discretionary order.
No, this is not a discretionary order with respect.
Absolute discretion.
Not 711 lies even with regard to if the entire claim can be rejected against one
Don't
defendant.
make advance arguments on 711.
Your lordship
Your prayer is under order 1 rule 10.
and under 711,
711.
11A.
If you argue
No
on
cause of action.
711, you are out of court.
Lords, your lordships
Cause
are
of
well in
action is made out. Simple.
I'm not just see. I've set out the judgments also in this note. I'll tell you what. In Church of Christ, your lordships have categorically held that even with regard to an individual defendant, if the entire plaint can be rejected, 711 lies. Now there is no cause of action shown against me. Just making a bold
Sir,
statement.
can entire plaint be rejected?
I'm sorry, Mlad.
Can entire plaint be rejected when there is an allegation of fraud against?
Entire
some of the-
plaint has to be rejected. There's no allegation of fraud against me.
Doesn't matter.
Just a.
For that, what the remedy?
No, there has to be
Order 1
some
rule
basis.
10, order 1 rule 10(2) will make your defendant a party, a misjoinder. So for that, it's the discretion of the judge to keep him as a proper party. Simple.
Look, I'm
If it's not a
only
necessary
saying
party, it's a
your
proper-
lordships have said that just by some artful pleading, look at the nature of the pleadings here. With this nature of pleading, every shareholder of every company will.
Mr. Singh, please come to page 26, opening line of ground C.
Page 26, Manoj.
Page 26, opening line of ground number C.
I'm sorry, just give me a moment, Manoj. Ground C, the High Court failed to appreciate that in these circumstances, the petitioner only being a shareholder of. Yes, I'm a shareholder of defendant number 1. The description is only that I'm a shareholder, nothing else. Which means lacks of, in every claim against a company, lacks of shareholders can be roped in as defendants.
We agree with you. He is not a necessary party, but he can always be treated as a proper party.
But there should some avowment against a party. I can understand if there was an averment that apart from being a shareholder, I have in some manner done some act, any act, even one act. There's nothing here, not a whisper.
Where is your most respected father in these days?
I'm sorry, Millet. Well,
Where is
really?
your most respected father in these days? The whole country is eagerly waiting for red carpeting for you.
Look, only one thing, look, then let it be clarified that I can only be a proper party. Now, here, please see, if there's no absolute absence of any averment, not a single averment against the party, Millet.
Not a case where we will.
Please, Your Lordship.
Appeal for the petitioner, my lord. Lord,
Yes, item 8.
yes. My lord, without hearing me on the first day, my lord, and then I've got I've got everything. Environmental clearance, consent to operate.
And approach the High Court.
No, I tell your lordship, my lord. They've passed this order, and now the next date is April. And running, my lord. I know the stone crusher. The moment you hear it, everybody nowadays has a prejudice. But then, my lord, for 3 months, I'm a small entity. I opened in December.
So you can request the.
They've just. I had lots to say without hearing me. At least issue notice to me, my lord.
Therefore, if you have not been heard, please go and apply to the High Court. We will make some observations. You can approach the High Court.
My lord, may I just a normal course? I should be.
Aggrieved by an interlocutory injunction order passed against him, passed against it by a division bench of the Uttarakhand High Court. Interlocutory order dated 7th January 2026 passed by a division bench of the Uttarakhand High Court. One of the grievances is that the order has been passed without even hearing the petitioner. So since the High Court is now opening after the summer winter break on 9th February 2026, first we say like this, it seems to us that the appropriate recourse for the petitioner would be to approach the High Court through appropriate applications for its impleadment as a party respondent, semicolon, to seek vacation stroke modification of the interim order, and to bring on record the set of facts which the petitioner wishes to, set of facts on the basis of which the petitioner claims that the song SAUNG, Song River, is a non-perennial river.
Can I just, sorry.
Since the High Court is opening after winter break on 9th February 2026, we request the High Court to entertain these applications and pass appropriate orders by preponing the next date of hearing. By preponing the next date of hearing, with the liberty of aforementioned, the special petition disposed of.
Can I just say one thing? I don't want to interrupt, my lord. My submission is that the relevant stretch of the Song River is non-perennial. That is the permission. Lordship, that Song Rivers, that is not my contention. I have produced documents. The document which they gave, is the reach of the Song River near Sankatiawala, Kala is non-perennial. That is my contention. Lordship will say relevant stretch of the Song River. That is my contention. My contention, even when I file a reply, is not, nobody can say the Song River is perennial or non-perennial. The relevant stretch, it's a huge river. This stretch, which is what the permission is given, the joint inspection report is on record, in which.
No, your contention is that you are away from the prohibited area on banks.
Sorry, my lord, sorry.
He's saying that the place where he's.
So, Lordship means relevant stretch of the Song River. That's.
Claims that, and to control non-perennial, that the site where the petitioner's stone crusher You have stone crusher.
Stone crusher.
Stone crusher is operational. The Song River at that, near to that site is non-perennial.
Yes. I won't say anything further. I won't read. Lordship may read annexure P10, how this order came to be passed. I
How
won't
can
say
it be
anything.
perennial
P10,
and at one point, the river
may
will
say-
be either perennial or non-perennial?
Lordship may see annexure P10. I won't say anything. Lordship may just read it. It was supposed to be listed along with a writ petition against my rival the next day. From this matter suddenly gets detagged and get listed. I won't say anything further. P10, Lordship may kindly see. I won't say anything further.
Anyway, we have requested the High Court to prepone the date and hear you.
No, sir.
You apply immediately and get
No,
an
the
audience.
consequences are grave. On one day without hearing a crusher stopped, the small entity, the whole.
Mr. Vasan, these
Yes.
are environment issues, precautionary principle guides the area.
With natural justice, my lord,
Right?
without
So
natural.
a precautionary principle, when there is an RTI report, the website of the irrigation department shows it as a perennial stretch.
Which is why hearing us, and I've given a perspective. Anyway, Lordship has given me that
completely,
liberty. I won't,
Lost sight of facts.
I'll leave it. But.
Obliged. Lordship, there are two matters before your Lordship, 9 and 9.1. In a similar matter, Lordship, at page 212, lecture P6,
2013 का date में
same order.
Double six, stroke 20.
My lords, we represent Ghaziabad Development Authority.
They are here.
As respondent 4 and respondent 3. The matter is coming out on 23rd of February.
Number 4 only or is number?
4 in 9, we are 4, and in 9.1, we are 3 respondent.
Should notice on behalf of the sponsor respondent, counter affidavit can be filed before 23rd February 26.
Please,
That they will decide all.
please,
Obliged.
obliged.
Ten? No. There is a letter. Item 10, there is a letter circulated.
This is the third time, my lord, the petitioner has been deboarded forcibly and illegally by the MP police and the RPO with connivance with the RPO police. This is the third time this incident happened, my lord. He was not permitted to travel beyond his origination.
So what can we do?
My lord, this is a
How
clear
we,
violation of-
how do we examine these facts that you were dropped on the way?
My lord, I have filed the documents, my lord, that police himself, they given that letter saying that we are deboarding you due to prevailing.
You don't have a place of protest in your state.
My lord, this is the case, my lord, where the.
No, you have a right.
Assured, my lord.
You see, we are not curtailing your right. You have a right to protest.
Yes, ma'am.
Peaceful protest.
My venue is not MP. It is the venue of Delhi.
Yes.
My venue is not MP.
Oh.
In the midway, we were.
Mr.
we were
Consul,
deboarded.
Mr. Consul, have you applied to Delhi government authorities?
Yes, my lord, that letter I have annexed.
Yes.
There's no reply. Kindly see the letter which I annexed, 4th of October, I applied for letter. I gave a letter.
Letter
number
you gave, have you
510.
obtained permission?
My lord, permission, no reply has come.
If no reply have come, that does not mean the permission has been granted.
Well, not even Lordship presume that even though no reply has come after the representation is given, that means there are no grievance for conducting dharna at
If
Delhi.
you are ready to listen to us, then you please appreciate.
Yes, ma'am.
There is an earmarked dedicated place for conducting peaceful protests.
Yes, ma'am.
There you can have a political rally, you can have a non-political rally, you can have the farmers whom you are saying that you represent. The farmers can come there, they can protest for their demands, whatever. That's a part of the democratic process, no difficulty.
Yes, ma'am.
And for that, there is an earmarked place.
Yes, ma'am.
So first go to that competent authority, apply and obtain the permission.
When I gave a letter, my letter, there is no reply.
The
When
DCPA
I even Lordship say that I have to apply before the competent authority, I gave a letter.
Yeah.
Even if the letter has to be given in person, I have to come to Delhi at least.
Yes.
But even half of the way, I was deboarded.
How have you, has he engaged you?
Pardon, my lord?
How has he engaged you?
My lord, he is from the same place.
So for the purpose of wakalatnama, for
No, my
purpose
lord,
of.
this is not the way, my lord. Kindly see this. There is a violation, a gross violation of 19(1)(d) and 19(1)(a).
Like to answer any question which we are asking you.
My lord, I'm saying, my lord,
How did he come to sign your wakalatnama and papers?
my lord, as a council, I have to sign it, my lord, that I filed a writ petition on his behalf.
You are filing without any wakalatnama.
No, Vakalatnama I filed, my
Is there?
Yes, my lord.
So he came to sign your wakalatnama?
No, he sent it by post, my lord.
Oh, like, he sent it from there. Now he has authorized you. Why can't you apply?
My lord, it is duly notarized by the local notary public.
Very good. So he has sent it. Now you are his authorized representative. Not
I send it, then there was no reply. That's why my submission. my
Go
lord.
and apply, please. Ask your clerk, you can apply online nowadays. You don't know to, even you are not required to go.
My lord, I'm not saying, my lord, because the question is that the appreciation has been given, no reply has come.
Well, I thank you very
Thereafter-
much. Thank
Huh?
you. No case to interfere with you.
My lord, at least, my lord, kindly see, my lord, the last date, last writ
No
petition.
case to entertain this writ petition is vague. So ये लिखो, the writ petition is completely vague, evasive, and full of misdirected governments. The same cannot be entertained, dismissed. हाँ, ये रोज भाई. Writ petition are dismissed.
Earlier, my lord, I was given permission to go to the High Court, my lord. I applied for the High Court, I filed a writ petition. There also they said we have no jurisdiction to entertain because you were deported MP.
No, but your standard does not permit to go to High Court. You are not, your standard is not less than Supreme Court. So you are rightly come
I
to.
went to High Court, order also I annexed, my lord. After that,
Very good.
after dismissal of the writ petition, I went to the High Court.
All right,
I
thank you.
pleaded before the High Court.
Thank
High
you
Court
very
said
much.
we have no
Thank you.
jurisdiction to stop anybody from MP, other than beyond jurisdiction of Madras. That
Thank
is the
you.
reason I have come before Lord.
All right, thank you very much. Next. Item 12.
Lordship, I apologize in this matter. I'm sorry I couldn't circulate later on time. Mr. Sibbal, who's leading me, he's unwell. So he asked me to make a request. I got information very late. I tried to circulate, but I had surpassed the time. So I'm just requesting 1 week adjournment, Lordship. He's not well. I spoke to him. So,
Your monopoly right is expiring when?
sorry, my lord.
May 2026.
Lordship, the patent will expire in May 2026. But there was an injunction till the time the division bench passed the order. So I'm just requesting for a week adjournment. There was an injunction throughout.
Next week.
Much obliged.
But if your lordship, so far as the SecPers lady is concerned, there is no allegation whatsoever. But please come to P4 at 61. That's the FIR. And if your lordships are kind enough just to see para 7 at page number 67. Apart from the invocation of 420, 406, etc. together, Lord, just come to para 7. Complainant, may I place it? May I place it?
Para 17 of?
Para 7 of the FIR, Lord, it said FIR will begin at page number 61. I would like your lordship to see para 7.
Yes.
The complainant ultimately advanced large sums totaling multiple millions of dollars, but as market conditions surged, accused persons began dealing, eventually ceasing delivery. So the whole issue is not, it's really a commercial transaction that we could not deliver because of change of market conditions. Others are surplusage and nothing against the lady, Lord. Nothing whatsoever against the second respondent in the entire FIR. Nothing incriminating. She's just been roped in because of relationship, Lord.
What is the stage of the investigation?
Lord, I must tell Lordship,
Yes,
I
yes.
stated, Lord, charge sheet has been filed.
Let it be investigated.
No, Lord, may I just say this? My Lord, charge sheet has been filed in the interim while the matter was pending in the High Court. Charge sheet has been filed, but I have not been served a copy of it, Lord. Charge sheet has been filed. It really makes out a civil transaction. I have not been served a copy yet because right now summons have not, process has not been issued. It's a case of not give or take of. Charge sheet was filed, Lord, but we don't have a copy. I can place that on record if your lordship permits.
Appear before the. Charge sheet has been filed, then go and.
I'm sorry, Lord?
If charge sheet has been filed, then go and seek your discharge as per law.
Lord, I leave it to your lordship, but not purely a commercial matter where they say it's only a question of delay.
Commercial law depends upon that initially what were intentions. If your intentions were right from the very beginning to dupe the investors, then you can't claim it a pure commercial transaction.
There was an MOU, and I must say this, for the second petitioner, there is, not this lady, there is nothing. May I just have a look at that for a moment?
Not a case that we can quest.
Lord, may I just make a request? Lord, may I make a request then? Not the concern, I leave your lordship with one more concern. Lord, I was protected till a certain point of time. Kindly just see.
We know that is
Page
only
20.
prayer.
That will be lengthier. You will be released on bail.
Therefore, and we'll take our remedies now.
Absolutely.
Yeah.
The petitioners are agreed by the judgment dated 22nd December 2025, passed by the High Court at Calcutta in bracket Port Blair bench, whereby their revision petition seeking question of FIR number 34/2025, dated 13 July 2025, registered at Cyber Crime Police Station, South Andaman, has been dismissed. We have heard Sri Siddharth Luthra and our senior counsel representing the petitioner and preview the report. It is clearly admitted that that after investigation, charge sheet has been filed. That means so, we are not inclined to entertain this petition. The petitioners, if so advised, may move an application for the discharge. Such an application shall be considered by the trial magistrate in accordance with the law. Next paragraph. With a view to enable the petitioners to join the court proceedings, it is directed that the arrest of the petitioner shall remain stayed. Share number 2. First petitioner company. It is directed that the arrest of petitioner's number. Petitioner is a company, Mr.
Sorry, not
Petitioner is a company.
number 2. Second
Number
petition number. Number 2, Latifa Banu.
Petitioners number 2, sir.
And there's three matters, not the other individual petitioners. In matter
Petitioners in
2,
SLP criminal number 1790/2026 and SLP criminal number 12.
we'll get the name.
825/2026 also shall remain stayed, subject to their surrendering before the trial court within 1 week and furnishing adequate bail bond to the satisfaction of the trial court. Also, the learned magistrate shall be at liberty to impose such other conditions as may be deemed appropriate, as may be deemed appropriate.
My lord, we make it 2 weeks is all I'm requesting instead of 1 week, because one of them is based here. Flights are sometimes a little problematic. 2
All right, 2 weeks.
And one request for discharge will not be influenced by the observations, because there are certain observations on merits.
Nothing, Mr.
My lord, there are some observations on merit, mensria, etc.
Thank you very much. Thank you.
Grateful.
Please, ma'am. My lord,
Description of sentence.
Yes, Mr.
please. My lord, the first round, my lord, the constables came and the ground was that they were simply following the directions of their superiors. Now, my lord, here, they are the advocates and the advocate was throughout present during the commission of the offense. The High Court records that CCTV is not clear and therefore his presence is disputed, whereas, my lord, there was a test identification parade in presence of an executive magistrate and thereafter followed by, my lord, his identification in the court. And, my lord, two, my lord, the High Court records the phone which was found and which was used by this person, my lord. That phone was lost by somebody 6 months back. That's also wrong because it is recovered from him at the time of arrest. Please have a look, my lord, at page. And please see, my lord, he was described as an unidentified person, and it was told in the first complaint that once I see him, I can identify. Therefore, a test identification parade was conducted, my lord. Now, please have a look at para 14, my lord. Page 15.
Test identification parade, because the FIR was delayed, was after 4 months of the incident.
My lord, there was an inquiry prior to that. There was an inquiry, my lord. And please see, my lord.
Lawyer's presence was not spelled out in the FIR.
No, my lord, please see. I'll just.
Then he goes to the Home Minister, and then the FIR gets registered in April.
It
with
was.
regard, we understand that.
Please,
there
please.
were some influence, etc. But still then the fact of delay.
Please.
We have to examine the identification in light of the fact of delay between the parties. And admittedly, this person was advising some of your partner.
No, my lord, he was never, my lord. The High Court records that his father was once upon a time an
Your
advocate.
father was the lawyer of your partner who is accused.
But my lord, he never appeared for me. Please see, therefore I'm pointing out, please see para page 15, my lord.
Yes.
Para 14, my lords, may have a look.
Yes, to say the point is that in a case where the
My lord, in the first round, my lord, when I pointed out that this may not be treated as a precedent, my lords have clarified in the order that in the peculiar facts and circumstances of the case, where they were constables, simply, my lord, following the directions of their superiors, my lord. Here, my lord, please see the police officers and IPS officers, my lord. The police officers are a former MLA is before my lords, my lord.
question is, it's the pendency of appeal. But the appeal will be heard, all these.
No, 4 months, 364A, life imprisonment. The evidence is on record. The findings are flawed.
High Court has made a fine distinction between the conspirators.
Therefore,
the superintendent of police has not been granted suspension. Your partner has not been granted suspension. It's the lawyer, the constable, and the former MLA who have been granted suspension.
But there should be
the
findings can't be, my lord, contrary while granting suspension, my lord, with all due respect. The findings can't be contrary to the record, my lord. Please see, therefore I am pointing out, kindly have 2 pages, my lord. Para 14 at page, my lord, 15. Kindly have a look, my lord.
Yes.
It says, my lord, the applicant was throughout remained present when the act of ransom and kidnapping being made by the police officials. Hence, facts remains that the CCTV footage relied upon the prosecution seems to be not as much as clear. My lord, I was there, I identified. And 2, my lord, now please see the second finding.
Mr. can clarify that this observation has nothing, will have no bearing on merits. But the point is that once bail has been granted, why?
Lord, yes, I can understand, but this is an offense, my lord. Please appreciate a police officer is posted, my lord, 400 kilometers away. He comes to Gandhinagar from Amreli, and then he abducts. Then there is a transfer of Bitcoin where this MLA is involved. The advocate is present throughout the incident, my lord. Even prior to that, in the conspiracy, my lord. In the conspiracy, right from 7th of February till 11th of February, they were in constant touch. The person who was released, that is Kirit Paladia, and my lord, this MLA and these lawyers were in constant touch, my lord, on phone. Those are CDRs on record. There were meetings in the circuit house, the government circuit house, my lord. That is all, that register is on record.
Question of connecting this entire evidence to establish that there was a meeting of mind or that there was
there is no
preconceived conspiracy. All these are matter of trial. Because
therefore, my lord, there was
substantial evidence.
But, my lord, if the findings, my lord, are prima facie in contradiction to the evidence on record, just kindly have a look, my lord, what the learned judge records, my lord. Only one thing. Here, my lord, the High Court records that, kindly see page 16, my lord. What the High Court has recorded. That the mobile number 816, the last digit, claimed to have lost 6 months back. And then please see page 443. It says there is a finding that further the mobile number so and so recovered from the accused Ketan as per the deposition of so and so. So there was a recovery. The High Court records that it got lost 6 months back. My lord, the findings are prima facie, my lord, in contradiction to the evidence on record. I can understand suspension, but please see, my lord. So at least, my lord,
Assuming it's an erroneous order, even then we should not interfere. Unless we find a complete pervert order going completely beyond jurisdiction, where the High Court.
My lord,
has
this is
rightfully
prima
recognized
facie in my respectful submission, my lord. Once the High Court records a finding which is contrary to the record, my lord, then what more perversity is required, my lord, with all due respect. And please see,
We have heard and sent counsel for the petitioner.
and two unidentified person, my lord, the High Court records he has not named. I was not actually knowing him.
At a considerable length.
He came in Elantra car, my lord. That Elantra car he borrowed. That witness evidence is there.
The impugned order that the impugned order pertains to suspension of sentence and grant of bail during pendency of criminal appeal. We are not inclined to appeal with the same. Especially.
And this may not be treated as precedent, my lord. Now the police officers are in line. At least my lords may say that, my lord. They may not get the benefit of parity, my lord. If at all my lords are, my lord, not intervening, my lord, because of the rules, my lord.
It goes without saying that such a prayer, if any made by the who accused who are police officials, or shall be dealt with by the High Court as per their own merit.
Please.
High Court has already rejected.
14 and 15, my lord. 15 is. No, the other police officers have not come. Only one, and he has withdrawn. My lord, only one. Only one. That is Kirit Paladia. He is not a police officer.
Police.
No, my lord. Superintendent of police. His application is.
No, that has been turned down.
No, it is
The High Court made
the
a
police inspector, my lord. Not the superintendent of police.
The superior police officer, the constable's bail were granted.
Constables were
The
granted.
superior police officer's bail has been turned down by the High Court.
No, only the
One
police
of them.
inspector, my lord. One of them.
Inspector.
The SP.
SP is two.
Yes, my lord. Now SP is waiting for
The
house.
inspector is down.
With the addition of this line, they will be taken care of.
Please, my lord. We are grateful.
Came out of 15 came out.
Please, my lord. My lord, this is a case where petitioner is seeking his right of hearing on the bail application. My lord, what is happening that bail applications are being filed by the litigants, and that is keep on adjourning without taking on the roster because of the heavy roster or any other reason. We have the compilation of इधर से दे दीजिए एक बार ये दिन दे दो तो My lord, we have the compilation of various cases where such type of practice is being done, my lord. Please, my lord, I have the list. I have prepared on my own. It is not the list of compilation of all such type of cases. But suppose the case is at serial number 3.
So there is a slightly unusual prayer made in this special petition. It seems that the petitioner has approached the High Court for grant of regular bail The petitioner has approached the High Court for grant of regular bail in a case registered under section 115, 190, 191 in bracket 3, 324 in bracket 5, and 351 in bracket 3 of the BNS 2023. The petitioner was arrested in that case on 11th August 2025. In bail application, we approached the High Court for grant of bail and his application came up before the High Court for hearing on 8th December 2025. It was adjourned to 20th February 2026. That is for a period of more than 2 months. The petitioner then applied for preponement, but by the impugned order dated 22nd December 25, his prayer has been declined on the ground that the bail application of his co-accused has already been dismissed. Next paragraph. During the course of hearing and on a query by this court, Komal and senior counsel for the petitioner submits that there are numerous bail applications pending in the High Court of Punjab and Haryana at Chandigarh, where matters are adjourned where the dates are being given months after, and as such the bail applications are not being decided for a long period. On a further query and on an illustrative basis, he has submitted a chart of some of the bail applications which are pending since October 2025 and are currently adjourned to since May 2025 and are currently adjourned to different dates in the month of March 2026. You are for the state.
Yes, Your Worship, I am appearing for state.
It's not your fault, maybe.
Yes, yes.
Your fault may be that because you might be taking date or you might not be producing the record. But this is not the way the High Court should deal with bail application. If you don't want to grant bail, you reject it. For 6 months, for 1 year, you don't decide the bail application.
My lord, I have given the suggested measures also, where the state is seeking time for filing status report and on any other, there are various reasons for which the bail applications are being pending. There can be mechanism, my lord, because 7 days time is always given in regular bail in High Court. Within that period, they should file the status report so that it cannot be adjourned. Because once adjourned, then it goes after 3 months.
We had introduced a system there that when you file the bail, we don't know now, you file the bail application, you will give an advance copy in the AG office, and when after a gap of 1 day, the bail will be listed and the IO will remain present in court.
Earlier it was being listed, but now.
Of course, now with the hybrid system, the IO can appear even online, but the bail application could be decided the very 3rd day.
Yes, but now it is listed after 7 days. And even within 7 days, no reply, no status report, no.
And that's why when we ask for the disposal, only these bail application disposal is shown. The regular matters are still pending there. All 1985, 86 RSAs of criminal appeals, everything is pending.
Please, it directly affects the liberty of the litigant.
Next paragraph. ये सारे सर्विसेज से जाते हैं ना ये क्या इन्होंने लाइफ में कुछ प्रॉब्लम at page 22, you can't blame the judge on a request made by counsel of the by the petitioner.
What is happening in some of the case is not being taken up. Thereafter, the council check the list. Then what is that on the request of the council adjourn and status report is awaited. There are also some of the cases. I have given 7, 8 suggestions, my lord, how it can be mechanized or improved, madam.
The biggest problem is that there is no orientation, there is no training system, there is no sensitization program of, after all, they are high court judges, they must themselves realize it.
My lord, I have given the copy.
क्या लिखा है? ROPs have also been produced in order to show that how the matters are being adjourned repeatedly, how the bail matters are being adjourned repeatedly. Next paragraph. All that we wish to observe at this stage is that we are extremely disappointed to see as how the prayers pertaining to the liberty of individuals are being dealt with. It may be true that the dockets are very heavy and there are other matters which do require prioritization. But amongst the miscellaneous matters, nothing can be more important than the decision of the fate of, nothing can be more important than deciding the fate of the prayer to grant or refuse bail. Next paragraph. We expect Honorable Chief Justice of the High Courts to take some remedial measures. इससे पहले एक paragraph और ऊपर almost shocking. Don't say shocking. It is equally disturbing to know that in the Patna High Court, bail applications are not listed even for preliminary hearing for months. And more than 14,000-15,000 matches are pending. One of us, Mera Likho, vividly recollect various matters coming to this court only for seeking direction only for listing of their bail applications before Patna High Court. We have no reason, next paragraph, we have no reason to doubt that Honorable the Chief Justice of the High Courts are cognizant of such prevailing conditions where the High Courts unfortunately are not even able to decide bail applications on time, within a reasonable time. This is happening despite the fact that on s- that on occasions, this court has indicated timeline for adjudication of such type of matters where there is an inbuilt urgency, keeping in view the very nature of a relief sought. It seems that those orders passed by this court have not been able to bring the desired sensitivity as a result of which, due to which, the high courts have apparently not evolved any robust mechanism for time-bound adjudication of the bail matters. Next paragraph. We are conscious of the fact that listing and prioritization of the matters for the purpose of listing is the exclusive prerogative of the Chief Justice of the High Courts, they being master of their respective rosters. So, however, if the people are languishing in jail, semicolon, their bail applications are not being even heard, and they are completely in and there is a complete uncertainty as to when will they be able to know the fate of their applications, comma, it seems that this court is under a bounden duty to lay down certain mandatory guidelines. However, before we do so, we direct the Registrar Generals of all the High Courts to send complete details of the anticipatory and regular bail applications pending in the respective pending in the respective High Courts, along with the date of filing, comma, date of decision, or the next date of hearing. All the bail applications, such details shall be furnished, comma, for the time being, in the respect of all the bail applications which came to be filed on or after 1st January 25, filed on or after 1st January 2025. So, bail applications filed prior to 1st January 2025 are also pending. जहाँ पे है ना anticipatory bail application, then stroke है ना application for suspension of sentence, three category. However, if such applications filed prior to 1st January 2025 are also pending, details thereof shall also be furnished. Next paragraph. Adverting to the case in hand, we find that the bail application filed by the petitioner is coming for hearing on 20th February 2026. We request the Honorable Judge to decide the same on merits, either on the date fixed or prior thereto, if an application or prior thereto, provided that the petitioner seeks postponement of date. Next paragraph. Within 4 weeks, post the matter for further consideration on so and so day. उसमें लिखना, all the state governments are directed to fully cooperate with the high courts for early and time-bound adjudication of the bail applications, stop prayer for suspension of sentence. The High Court shall sentence to the states should be ready with the relevant information as and when the bail application is listed for hearing, provided that a copy thereof has been handed over to, has been submitted in the Office of Advocate General and or the public prosecutor at least 3 days in advance. At least 3 days in advance. In such like matters, the investigating officers or the authorized officer can be permitted to appear online also. Next paragraph. The Registrar General of the High Courts are further directed to circulate disorder amongst the honorable judges of their High Courts with our fervent appeal to them for expeditious disposal of the pending bail applications. Next paragraph. The Honorable Chief Justices are also requested to revisit their roster stroke listing arrangements. And wherever they find that there is a mismatch between the total pendency and the bench allocated for deciding such matters, comma, they may consider the desirability of listing the bail matters before. They may expand the roster for listing of the bail matters. Post the matter on so and so date.
May I make one more submission, my lord? My lord, in cases of suspension of sentence, sometime what is happening that custody is more than 7, 8 or 10 years. Suspension of sentence bail application either pending or disposed of by listing the appeal. But appeals are also not being heard. And 7 years custody, 10 years custody after conviction of total, my lord may also call the record. The appeals in which custody is almost.
Say, Dr. Pankaj, that there are the system that has its own difficulty. If you start taking your only criminal appeal, the matrimonial appeal, the matrimonial cases, the other admission matters, academic matters, those get delayed. Some balancing has to be done.
There is no doubt that that is heavy roster, but 10 years custody is something.
No, undoubtedly, we don't, we strongly disapprove rather, if there is custody of more than 10 years, even normally in a case of life sentence, barring a few cases where death sentence is there or the crime is so heinous that life imprisonment means that he has to spend 40 years or so. In such cases, there is no question of granting bail. But then you pass an order, dismiss it, matter ends. Somebody would have, they have a right to go in appeal, let them come. But keeping pending is what is bothering us. You pass an order, that is prerogative of the judge. Whatever order they want, they let them pass. Right, let us see what.
Items 36, 37 are those Bengal SRs. In the sequence, it was supposed to come after 16. So is that being taken up?
We'll take up to.
Because the sequence was issued this morning. It said it's after item 16. Items 36 and 37.
After these.
Fresh matters.
1 or 2 fresh matters are left.
Yes.
After that.
These are fresh. 36, 37 are fresh matters. Bengal SIR.
Those are going to take with us.
I am grateful.
Just a minute, only 2 matters are left.
Very well.
I'm grateful.
Yes, item 40.
Yes, my lord, I appear for the petition.
You can argue from there now.
Only difficulty is, my lords, the elections are slated to, my lords, on Friday. My lords, my objection was dismissed only on 22nd. Also on 23rd, immediately I have moved the High Court.
Pending.
Immediately before the High Court, I have moved, my lords, the very next day.
They want to oust your opponent at the stage of nomination itself.
No.
You don't want to face in the election.
No, my lords, the only difficulty is that, my lords, I have moved the High Court immediately on the next day. My lords, no hearing has been given.
If you win the election, then he is out by itself.
That is it.
Okay.
May I only make one request, my lords?
23rd. Options open.
Yeah.
Not
I'll
legal
withdraw,
options.
I'll withdraw this petition. Lord's only request is that, Lord's, this objection I may be allowed to raise at an appropriate stage.
Entitled to.
Because, Lord's, the difficulty I'll face otherwise is that the order of the returning officer which is against me.
Counsel for the petitioner seeks and permit to withdraw this petition with the liberty to raise all the, to take or to raise all the contention at an appropriate stage. Order to court.
Very. I am highly grateful.
Item 41.
Lordship, almost more than 90% encroachment has been removed from the government and forest land, Lordship. This fact is already acknowledged by the respondent number 2 to 5, Lordship. May I read, Lordship, next year P5, Lordship? Page number 36, Lordship.
But why not remaining 10%?
Actually, Lordship, but there is a one BAME, Lordship.